Good evening, everyone. We're very pleased to welcome you to tonight's webinar brought to you by Lishan Talk Channel. And this evening, we are particularly honored to be able to hear from Greg Harris, who will introduce himself, and his topic is Semiconductor Industry Commercial Contracts, Key Challenges and Best Practices. As you will see from his bio, Greg is the best person to address this topic, having worked for several years in TSMC. And he, this evening, is going to share his extensive expertise in this area, which we hope will be valuable for all of our law firm lawyers and in-house lawyers who are working in the semiconductor industry space. So with that, Greg, I'll turn it over to you and allow you to introduce yourself and proceed with your presentation this evening.
Yeah, thank you so much, Robert, and thank you for everybody for joining us. This actually is a great topic. It's one that I'm very passionate about. Actually, it's one of the things that first brought me to Asia. So I'm originally from Canada. I went to McGill University in Montreal for my law degree, and I practiced in Canada for several years. But developments in Asia, including the flourishing of the semiconductor industry, first brought me to China about 10 years ago. Initially, I was in Taiwan, where I worked at the largest law office in Taiwan, Lee & Lee. And actually, at that point, I was based in Hsinchu, which is really the epicenter of, I would say, the semiconductor industry, not just in Taiwan, but arguably in all of Asia. I was there for several years before I moved over to the mainland side. I worked at several international firms in Beijing and Shanghai. And eventually in 2019, I actually made the switch back to Taiwan, this time in-house, where I worked at TSMC. And that was year-end 2019, and I was there until 2022. And that actually was a very fascinating time for the industry. A lot of growth, a lot of transformation, a lot of interesting things happening, and actually particularly interesting time to be in legal, which brings me to the specific topic of our discussion this evening. It is semiconductor industry commercial contracts. So why did I pick this topic? Now, as I said a moment ago, this is really a flourishing industry. Demand is just booming. Actually, the semiconductor industry, it is projected to double. It's already enormous, but it's projected to double in size in the next 10 years. But at the same time, it's also an industry that's really being reshaped in ways that are, for us in legal, fundamentally very challenging. So what am I talking about? In broad strokes, I would say there are three changes happening right now, three trends, and these are still ongoing. This is an ongoing evolution. First, one thing I think everyone would be familiar with to some degree would be the geopolitical tensions, in particular between the US and China, that have fragmented what was previously a very global, unified supply chain. That's a big challenge, and it's ongoing. The second would be very, very rapid pace of technological advance. And you might not think that that's a challenge per se. You might think that that's a good thing. But what it's done is it's created several very, very challenging bottlenecks where there are certain key technologies where you'll have one or two key players. As we'll talk about later, that complicates negotiations a great deal. And the third will be increased government involvement. Now, there's a lot I could say about that, but for our purposes, I would just mainly mention that because of all the subsidies in certain jurisdictions, the US would be one such example, a lot of demand has materialized all at once. And this has led to a very unique situation where supply is massively outstripped by demand. So this has a significant impact across the industry. It definitely impacts us in legal. When most people think about this, I would say they tend to focus in on export controls and the increased burden on compliance. And there's a lot's been written about that. What I would like to talk about, though, is a topic that's somewhat different, but I would say no less important. I want to talk about how this impacts commercial contracts. I think that's more relevant for this audience, which I think is mostly going to be Chinese legal professionals, be they in-house or in firms. In particular, I want to talk about first is procurement of semiconductor tools and materials and how that has become incredibly challenging for us on the supply side, for the purchaser side, that is. And the second, I want to pivot back to the export controls, but I don't want to talk about the specifics of the controls too much. What I want to focus on is how they impact commercial contracts, which I also think is a huge issue that, well, I think it really is more relevant in China than it is anywhere else in the world, possible exception of Russia. So let's just dive into the first topic because there's a lot to discuss. Procurement of semiconductor tools and materials. So you'll see I have the abbreviation SME, that's just semiconductor manufacturing equipment. Now, this has long been a very, very important piece of work for in-house lawyers or lawyers in private practice with semiconductor clients. The reason for that is, well, I guess it's twofold. One is that semiconductors, in particular, semiconductor manufacturing, it's really the most capital-intensive business in the world. I mean, the machinery in these semiconductor factories, we call them fabs or foundries in the industry. They are just magnificently expensive. So you probably heard, for example, of the EUV machine, the extreme ultraviolet photolithography machine made by ASML in the Netherlands. That's a key piece of machinery, I would say, an essential piece of machinery for basically any advanced node IC. That costs about 120 million US. And typically at foundries, well, I mean, a foundry won't just have just one of these. So they're very expensive. A leading edge fab would be about, well, the ones that we were building in the US when I was at TSMC, I think that was about 40 billion for two fabs. It's now gone up to 60 as the scope of the project has expanded. So very expensive. The second point, and this one's a little bit more difficult to understand for those outside the industry, is that this machinery depreciates very rapidly. So some of you, if you know the industry, you might have heard of Moore's Law, which is basically the notion to the effect that semiconductors typically double in speed about every 18 months or so. We don't have to get into why specifically, but that's just a function and a reflection of the fact that the technology in this industry moves very, very quickly. So you can buy a piece of machinery that's cutting edge, January 2022, but a year and a half later, 2 years later, I wouldn't say it's obsolete, but it's mature. So two things to keep in mind, because this plays into massively the strategies that you're going to want to take when you're negotiating procurement contracts. So this has always been the case, but recent developments have actually made things more challenging. So as I mentioned earlier, because of some macroeconomic and geopolitical changes, there has been a sudden surge in demand for semiconductors and for semiconductor equipment. And because the technology is evolving so rapidly, what we have is a very peculiar environment that is actually uniquely supplier friendly. It's very, very challenging for the suppliers. And in case this is not already understood, for Chinese companies in this industry, most of their procurement is going to be from overseas. So SME is still very much dominated by primarily the US, also the Netherlands because of the photolithography technology at ASML, and then to a lesser extent Japan and somewhat Germany. So very relevant issue here, China side. So I've talked a lot about macroeconomics, geopolitics, that sort of thing. What does that mean in practical terms when you're drafting, when you're negotiating? If there's one thing you take away from this part of the talk about procurement, It's that timing is absolutely everything. I've dealt with quite a few of these agreements in my time in private practice in Taiwan and then in-house. And this is typically the part of the agreement. Maybe it's not legally the most complex, but it is the most heavily negotiated because from a commercial standpoint, it's absolutely crucial. So I'm going to explain why, and I'm going to explain how to negotiate that challenge. And in doing so, I'm going to make occasional reference to the EUV machine that I just mentioned. But please don't misinterpret that. What I'm saying applies really very broadly to almost all semiconductor tools at this point. It's not just about one machine. I'm just using this because I think people are perhaps already familiar with this device. And also the photolithography machine, in some ways, I mean, every machine is indispensable, but in some ways, because it's the most expensive, it's sort of the centerpiece of the fab. And actually, because it's the most complicated, it has the longest lead times. It can take over a year for one of these to be put together, delivered, and then installed. So in a lot of ways, everything is downstream from that. So with that in mind, how do we deal with this if we are a purchaser and we want to procure an EUV machine or a similarly complicated and expensive piece of technology? Well, I mean, the first thing to keep in mind, and I'm going to talk about two things, is fairly obvious, is that you want to protect yourself against late delivery. This really is absolutely crucial. As I said a moment ago, if you're missing a tool, you cannot commence with production. So late delivery from one tool affects the usability of all the other tools. You do not want to be in a situation where you have a full suite of tools, you're missing one, and then they're rapidly depreciating. You can't use them. They're gradually becoming more and more mature. And also, if you're not using these things, it gets a little bit more difficult to maintain them. I'll say more about that later. So the best, at least the most common way to guard against late delivery of a tool would be a robust liquidated damages clause. And again, the goal here really is to avoid them. You're not so much after the money, you just want the tool on time. Failing that, these are also useful because if delivery is late, it's sort of something you can use as a threat to avoid litigation, to resolve things semi-amicably. And if worse comes to worse and you do wind up in a dispute in litigation, it will strengthen your position. So in terms of specifically what should one of these clauses look like? Actually, that's a very difficult question. I would say a liquidation damages clause are always going to vary from circumstance to circumstance. And they're going to depend mainly on the bargaining power of the different parties. I would say that's the key factor. One other thing that you're going to want to keep in mind is you're going to want to be mindful of the governing law. The reason being is that if a liquidated damages clause is too severe, it may not be enforceable. So it's usually good to look at the case law. And that's going to differ from jurisdiction to jurisdiction. But yes, ultimately the language will vary, but your key focus should be avoiding that particular pitfall. You want to make the damages as high as possible to provide a maximum possible incentive for timely delivery, while at the same time avoiding any risk that this thing is unenforceable to the point where a judge throws it out, or even worse, the other side, they know it's unenforceable, but I think very likely it's unenforceable, and they just don't take it seriously. So again, this is actually something I drafted based on things that I've seen, and it's a sort of a simplified example of what something like this, what a liquidated damages clause in one of these procurement contracts could look like. So very short language. I think that the key elements here are pretty obvious. In the event that a supplier is responsible for delayed delivery and purchaser can credibly establish damage, supplier will pay 5/100ths of the purchase price per day, and then there's a 10% cap. So I would say that this is maybe middle of the road. I would not say that this is very purchaser friendly. The reason why I would say that is there's a requirement that the purchaser prove that some damage has occurred. Not how much, but they do have to prove something, and that's a hurdle that you would otherwise not want. I would say 0.05% per day is, it's always hard to judge these things. It's hard to say what's market, but I would not say that that's high. And 10% as a cap, I would say that that's relatively low. Now, I chose a language that was not overly purchaser friendly because I think that's a good reflection of what the market is like today. Actually, it's a good reflection of what the market has been like for the past several years and what it's likely to be like going forward. So there you go. Practical advice on one step you can take to help guard against late delivery. So I mentioned a moment ago there are two things that I want to talk about that you can do to ensure that the timing is right in delivery. So the first one is protecting against late delivery. Can anyone hazard to guess what the second one is? Robert? You don't?
Nope,
Okay.
we're in your hands. We're happy to have you tell us.
Okay, well, I don't want to keep you in suspense, and I find this very interesting. I remember, my first day on the job, when I first discovered this, I was, I found it very intriguing. I still do, actually. It's interesting. Let me tell you what it is. So you actually, as the purchaser, you're going to want the right to delay the purchase. Why? It's not obvious at the outset, at least it wasn't obvious to me, but the reality is that purchasers, they're not perfect either. They are subject to delay. So they may find themselves in a situation where they have a production problem and they're not ready for the machine. Or the demand that they forecast is not materializing and they couldn't really use the machine at full capacity. Or what you're seeing now, you're seeing this a lot, and I can't get into specific cases, but I know this is happening because we're getting so many companies building in jurisdictions that are new to them. You're getting construction delay. And this is the most dangerous one. Why is that? Well, it's like I said a moment ago, this is very advanced machinery, and it's also very fragile. It's very, very difficult to maintain. So if you're building a factory, and let's just say you have a construction issue, or maybe even you don't get the permits for the water, for the electricity, and then ASML or one of your suppliers knocks on the door and say, hey, we're here to install your EUV machine. That's terrible news. Absolutely terrible news. Because these things are very, very difficult to store and maintain. You can't just put it in the box and put it in the closet and wait. No, it doesn't work like that. They have to be hooked up to utilities all the time. They have to be running, and they have to be stored in a very, very controlled environment. Otherwise, the tool will be physically damaged, and it will not be easy to fix. So this is extremely important. Now, how do you deal with that? It's not simple. It's not straightforward how you deal with that. You're going to want an option to delay, but it's not enough just to let the seller sell the machine to somebody else and you wait for the next one. Now, the seller could easily do that. Again, using the photolithography machines as an example. They're highly customizable and very, very bespoke, but that's all in the software. The hardware really does not change that much from one company to another. So from the supplier standpoint, they can fairly easily reconfigure it, sell it to somebody else, maybe keep your deposit and move on. But you don't want that because you're losing your spot on the queue. Remember, the lead times are very, very long. And actually, in all probability, that machine is going to a competitor. So that's not good. That's not a good outcome. What will be a good outcome? Best case scenario is the purchaser gets an option to delay at no cost, and the supplier agrees to store the tool and to defray the cost of storage, which are mightily expensive. Now, if you've been listening to what I've been saying so far, you probably clued into the fact that that's not going to be easy to get. It's just the law of supply and demand as it exists right now, first half 2024. But there are things you can do. It's going to be difficult. It's not impossible, and there are certain things you can do to maximize your chances. Now, this is not really legal advice, but I think this is good advice, and I've seen this really work its magic in practice. So it is a difficult environment. Even the large purchasers with a lot of leverage are going to struggle. So the best thing you could do when you're in-house legal at a purchaser is you try to leverage the relationships. And believe it or not, the relationships between in-house legal at a purchaser and a supplier, in my experience, don't count for that much. I wouldn't say they count for nothing, but they don't count for that much. Where you're really going to be able to break some log jams and make things move when they really seem like they're stuck is when you are the purchaser, you go to your procurement team, because you're going to work with them a lot anyway. And they, for certain, will have existing relationships, or at least the communication channel with the sales team at the supplier. And the sales team, they're very incentivized to make this happen, and they're persuasive people because they're in sales. So they will, they have cards they can play with the in-house legal supplier side. And like I said, this is not legal advice per se, but I really feel like it's good advice. So, from someone who's worked in-house and seen these things happen or not happen or happen very slowly, key to keep this in mind. And while we're on the topic of commercial realities, practical advice, I want to tell you something else. Now, if you've not worked on these before, you might not know this, but one of the things that I've observed and other people, other friends, colleagues in the industry have observed is we spend a lot of time negotiating these protections. So liquidated damages or right to delay or whatever. But we, generally speaking, we don't know of many instances where these are actually enforced. And the reason being is, it's like I said earlier, it's the nature of the industry where there are actually very few players. We've seen a lot of consolidation because it's so capital intensive and it's so high tech. There are very few people who can do this. And again, right now, it's like I said, it's very, very supplier friendly. So we don't want to compromise those relationships. So with that in mind, some people have asked, they've asked me, why bother? And I think I have a good answer. The first thing I would say is, I've been involved in this industry for a long time, actually, since 2015. And it wasn't always like this. Actually, many people might not realize this because they only started paying attention to chip shortage in 2020. But this is one of the most cyclical industries out there. And sooner or later, things are going to shift back in the opposite direction. I mean, it might not be total opposite of what it is now, but it'll be closer to normal. And you could even see, as we did during the great financial crisis and the big recession in 2008, you could see a glut of some semiconductor tools. And again, the thing to keep in mind, you might think, well, how does that help me? Something that might happen in the future. You have to remember, because the lead times are so long, a year could elapse between the day that this thing is signed and the delivery date. A lot can change in a year in terms of macroeconomics, in terms of regulatory environment. So it is important. You have to have this in your back pocket, because there may very well come a day when you want to use it. And I think just more importantly, all of these questions about relationships and whether to enforce your rights to the full letter of the provisions that you've drafted. That's ultimately, I think, a business decision, and you're really doing your job as a lawyer if you put your colleagues who are going to make that decision, because it's probably not legal. If you put them in the best position possible, if you give them as much latitude as possible, as much freedom to maneuver, they're going to thank you. So I think I've said my piece for tonight on procurement contracts. I'd like to move on to the next topic. So as you can see, next topic is export controls and how they impact commercial contracts, as though they weren't complicated enough. So this is really a key issue for in-house legal, especially on the purchasing side and especially here in China. It's one that actually, unlike some of the procurement challenges that I outlined, this is relatively new. I would not say that this was a big issue prior to 2020. I would say it's going to get more important. This is not, we're really shooting at a moving target here. Every year, it feels like these things are being updated, and they're really only moving generally in one direction, which is getting stricter and stricter, getting broader and broader. So these things have a very big impact. It's a growing impact. And I think from a commercial contract standpoint, you can see it manifest in two areas. The first will be procurement contracts, very much like the ones I just mentioned for semiconductor manufacturing equipment. And the second would be really the bread and butter of the industry, the foundry service agreement, where you're actually selling IC, you're selling chips, the core product. So this slide is really just a teaser. I would love to talk about export controls all night, but we don't have all night, and we would really need all night to do this topic justice, because it's very complicated, it's very important, and it's constantly changing. So this is not even an overview. I'm just mentioning the topic, maybe for some of you who perhaps haven't heard of this before. Essentially, the way this works is, and I'm just limiting this mention to U.S. export controls. I won't talk about anything from the Netherlands, the EU, what have you. In its simplest form, the way this works is these are administered by the Bureau of Commerce, by the Department of Commerce, by the Bureau of Industry and Security. They administer export administration regulations, one component of which is the commercial control list. And the commercial control list contains, it's a list of all the items that you would need potentially a license for to export, to re-export, or to transfer within country. And the list of semiconductor related items is growing on the commercial control list. There are more and more items targeting China's ability to purchase and manufacture advanced chips. So either to purchase the chips themselves or to purchase the equipment that you need to manufacture. Like I said, in its simplest form, that's how it functions. But it has more complicated forms as well. So you might be dealing with a situation where actually you're likely to be dealing with a situation where the manufacturer is not in the US. Because in this day and age, most leading node ICs are not manufactured in the US. They're either in South Korea or Taiwan side here in China. And this is where some of the foreign direct product rules can come into play. Now you see I bolded and I underlined the S because there's more than just one rule. There's several of them, and they are very complicated. I'll just talk very briefly about the entity list foreign direct product rule and use that as an example. So if a company is placed on the entity list, the entity list foreign direct product rule can prohibit actually a foreign manufacturer operating overseas from re-exporting to that country if the product in question contains a non-de minimis amount of US technology. So when I say de minimis, it just has to be over a certain threshold. Um, Beyond that, we also have end use and user controls. So this is sort of approaching it from another angle, not so much the item itself, but what is the end use? What is the end user? And then finally, there are even now restrictions on US person support that are preventing, by way of example, US individuals from, say, what would be an example of servicing a product in mainland China at a company covered by export controls. So I hope that's enough to whet your appetite, because it's all the time we could spend focusing on what these controls are and how they function. I want to now pivot to the core topic, which is how they impact commercial contracts. And really prior to 2020, when I was in Hsinchu in 2015, 2016, I don't remember these being talked about. I do remember occasionally seeing them in agreements, usually in the just the boilerplate, the applicable law section of a foundry service agreement or a procurement contract. But it's really just saying something like, "Oh, all parties will abide by applicable law," and export controls just might be mentioned by way of an example. But I can tell you, compared to what it is now, back then it was an afterthought, if it was thought about at all. So when you're dealing with old contracts, it's extremely difficult, actually, because they're typically not dealt with in a straightforward, explicit manner, which is what you want. The only tool that you have in most cases is going to be the force majeure language, and that is not straightforward, I would say. Now, force majeure, as a creature of contract, its very nature is to deal with unpredictable events. So it by its very nature, it can't regulate everything. So that is quite complicated, and we'll get into some of the ins and outs, some of the challenges of trying to apply one of these. But the end result, before we do that, just want to say why this is important, because in a situation such as this, where you have a key issue, it's basically making the contract maybe impossible to perform. And it's unclear how to proceed. Dispute is very, very likely. So you want to marshal every tool that you have in your contract to further your company, your client's best interests. It's unclear how to proceed, and in this context, especially where the export controls are very strict and they're effectively a total prohibition on commercial dealings between the two parties. That means the end of the commercial relationship. That means there's no incentive to compromise. It means a dispute is very, very likely. So, what do you do to either forestall that or to maximize your chances? Again, it's this is the reality of contract law. You can work with what's in the contract. You can work with what you've drafted. And for our purposes, I want to walk through each of these points one by one, spending most time on the first one, force majeure. What is that? How do you use that to defend your interests? Then I want to pivot to other clauses: limitation of liability, dispute resolution, governing law. How do all of these clauses, how does this language come into play when you have a supplier that's saying all of a sudden that it can no longer deliver? Okay. So we'll start with force majeure. Again, as I said, what's in the contract is pivotally important. Why? Well, in common law, force majeure really does not exist, just sort of out there floating in the common law. It very much is a creature of contract law. So if it's not written into the contract, it doesn't exist. If you haven't written something like this and your contract is common law governed, you're really falling back on the doctrine of frustration or maybe illegality or something like that. You don't want to find yourself in that situation. Pivoting to civil law is a little bit better. Force majeure is something that will be codified. I mean, to put it this way, it's been codified in every civil code that I've ever reviewed. So I mentioned at the outset, I'm Canadian in terms of my background and my legal training. And I actually went to law school in Quebec, which is a civil law jurisdiction. So it's really the same wherever you go, any civil law jurisdiction. Quebec Civil Law Code has a force majeure clause. Taiwan Civil Law Code has a force majeure clause. And here in the mainland, we also have. But the trouble is these things are never they're never very well developed. They're not meant to be. So civil code is just meant to provide a distillate, a very succinct statement of what the law is on a particular point. And I think the PRC Civil Code is a very good example of that. So this is it in its entirety. Article 180. So it simply states what the law is. Force majeure is a person that is unable to perform its obligations due to a force majeure bears no civil liability. And then it provides I think a very standard but not detailed definition of what force majeure is. So any objective conditions which are unforeseeable, unavoidable, and insurmountable. And I think that's good as far as a civil code article goes. What we had in the Quebec Civil Code is very similar. The one that I've reviewed in Taiwan, again, not that different. But it's not going to help you resolve a major commercial dispute for, a piece of machinery that costs $120 million, or a huge order of integrated circuits, which if your company doesn't get, is going to maybe kill their handset business or cripple their operations for the foreseeable future. You need a lot more than that. And actually, most force majeure languages in contracts that I've read in this industry, they don't deliver on that. They come closer. So what I have here, all done up in this gaudy yellow highlights is these are two separate clauses. One is very short and it's very, very supplier friendly. The other is a lot longer. I would say that makes it better. And it's a bit more balanced. So, I think Robert will circulate the slides probably later, so we don't have to go through these word for word. But again, pay attention to the things that I highlighted. These are some of the key points. So start with the one on the top, the shorter one. Neither party is responsible for delay or failure of performance, with an exception for breach of confidence. They're not responsible to the extent that they are hindered in their performance by any occurrence beyond their control. And then we have some examples of that: act of God, fire, government restraint, etc. So that's the first one. As you can see, I highlighted a couple of things here. I highlighted the word hindered. You normally don't see that. Normally you see prevented. Hindered is a much lower standard. It's going to let the supplier get off the hook much more easily. Say more about that later. The second, one of the things I do like about this is that at least mentions government restraint. That might seem like a basic thing to do, a new law, government action, something like that, is one of the things that can legitimately interfere with the contract, make it impossible to perform. And it is outside of the party's control. So they mentioned that, and that's good. Pivoting to the second one, they actually don't have that. Let's look at the second one. So neither party will be held responsible for delay or failure, okay, to the extent that this is caused by an act of God or other similar causes. So that's, for me, that's really not great because they haven't, they've left it very vague. When they say other similar causes, they have left the door open, very broad. That's sort of a catch-all that can encompass a lot. But they have not really fleshed it out, which I think is not great. What I do think is great is moving further down, past their very mediocre definition of force majeure event, you will see that whoever drafted this clause, they did spell out in considerable detail things like the obligation to mitigate. So the party claiming that they're subject to force majeure, they have an obligation to try to overcome the force majeure as best as they can, deliver at least in part. That's very good. I think commercially very reasonable, very much in keeping with the purpose of force majeure. They have to provide written notice. within 24 hours, which I think is far too short for this industry, given the time differences that you're often dealing with. And yeah, and then at the end, which I think is most key, it actually says what the consequences are. You notice in the first clause they don't say, "Oh, okay, so what? Neither party is responsible. Okay, what next?" At least here they say, "Okay, it's suspended for the time being, and if it lasts however long, I think they wrote beyond 20 days, then the customer or the purchaser, they have a right to terminate." Okay, so that's a rough overview of the anatomy of what an actual force majeure clause in a semiconductor procurement. Actually, those are both from foundry service agreements. Those are both from actual semiconductor foundries. And I would hasten to add that those are both pre-2020. So the language might look somewhat differently if the contract will be signed tomorrow. But those actually are industry examples. I didn't really change them that much. So look, in terms of what you do, if you're at a purchaser and your suppliers, they're saying they can't sell, or worse yet, they've already sold, but they're saying they can't deliver. How do you impose some order on the dispute that's taking shape? I would say you look at the force majeure clause and you want to focus your attention on 4 points. So the first is, what is the definition of a force majeure? Usually it will say government action, government restraints, something like that, or government laws and regulations. And you on the face of it, export controls do fall into that bucket. I think they do fit that description on the face of it. What I think you'll find is that when you look a little bit deeper, it's much more complicated. What do I mean by that? I would say, yeah, I mean, I would like to say 3 things that might not immediately be apparent. One is that a lot of these export controls, they function extraterritorially. So if the Department of Commerce in the United States has passed an export control and it's meant to function extraterritorially to a party, commercial party could be in Singapore, could be in South Korea, could be anywhere. I mean, in some sense, they're not directly subject to that department of the U.S. federal government's jurisdiction. And they have to make it arguably, they're making a decision to comply. And I think in a lot of cases, a very straightforward decision, because the commercial consequences will be disastrous if they don't. And there are ways in which the Bureau of Industry and Standards, the Department of Commerce, can pursue them legally. But in some sense, they do choose. And in some cases, they go even further than this, wanting to stay on side with what is a very increasingly important organ of the U.S. government in this industry, is they will actually choose a very risk-averse, overly cautious approach that goes above and beyond complying with the letter of the law. So this is a bit of an old example, but I think it illustrates the point perfectly. So you'll recall 2 or 3 slides back when I talked about the entity list foreign direct product rule. That was initially, its scope now is much broader, but that was initially mainly focused on Huawei. And Huawei, believe it or not, at one point, they were the second biggest customer of TSMC, right after Apple. And again, this is all public information. I'm not telling you anything sort of insider here. If you're interested, you could read about this in the Wall Street Journal. And I encourage you to do so. It's quite interesting. It makes the point very well. What happened there is the first entity list foreign direct product rule was not very well drafted, and it failed to take into account that a lot of Huawei purchases of semiconductors, they're not delivered to Huawei. They're actually delivered to Foxconn. But this is something, it's actually a very, very basic feature of that industry, consumer electronics generally, contract manufacturing. A company like Huawei, a company like Apple, They don't make their own stuff. Come on. But they missed it. And actually, people at the Department of Commerce, they did go on record say, yes, technically it's true. The letter of the law would not permit sales of the items in question to Foxconn, even if Foxconn is accepting delivery on behalf of Huawei. Now, they also said that they hoped, they expected that foreign manufacturers would comply with the spirit of the law. And I mean, really, who wants to do that? No, nobody. I mean, if TSMC and these foundries, they have their way, they want to sell to everybody. But I think knowing how politically charged this issue is, and knowing that this is a moving target, they actually they went on the record saying we are going to comply with the spirit of the law. So in that sense, is it really force majeure? Not so clear. I would say you have to look at the language, and that's why I highlighted the word hindered. Okay, if they said prevented, if you're excused when the force majeure event prevents you from complying, I would say no. That doesn't rise to the level of prevention. You're not, strictly speaking, legally barred from doing this. It's probably going to become very unprofitable for you to follow through with that delivery. It's very unwise. It's commercially highly unsound. It does make performance more difficult. So wait a minute. If we've written in the contract hindered or impeded, yeah, I would say if you've chosen that language, if you are the seller's counsel and you drafted that language, I would say you deserve a bonus, or at least an afternoon off, because that's great legal work. So look, I've harped on this point enough. I think you get the point, you get the message. You have to read these things very carefully. They're not champagne. They're not all cookie cutter clauses. They do vary a great deal, and these differences matter. The difference in that one word is the difference between a breach and effectively a right to unilaterally terminate a contract. So I find that very interesting. Moving on, another topic that's also very interesting would be mitigation. So again, remember, the first clause didn't mention this. They were silent on to what extent does the party invoking the clause have an obligation to overcome the force majeure, to try to mitigate the challenge to perform the contract as best they can. The second contract did say they have an obligation to mitigate. So what does that mean? In practice, I don't think we're really sure. I don't know of a case where this has ever been litigated, and but I do think it's worth asking. Does that mean, for example, the supplier is obliged to apply for a license? Because maybe I didn't do the best job explaining this because I didn't get too much into details. But you can apply to the relevant authorities in the U.S. for a license. Now, these applications are heard under presumption of denial, so you're not likely to get one. But I would say in certain circumstances, again, it depends on what the language is. If you have an obligation to mitigate, I would think that probably does entail an obligation to apply for a license. Because what you'll find is more often than not, the language will say use all commercially reasonable means to mitigate or something like that. And I think filing an administrative application for a license so you can deliver a product that you've probably already sold I think is reasonable. Now, would an obligation to mitigate, depending on how it's drafted, would that entail an obligation to rework a product, to make it make it an IC so it's a bit slower, or rework a machine so it contains less US technology and is not subject to one of these rules? Again, it depends on the language. I would say probably not. I would say less likely. It's just, I mean, if you're actually changing, you have to go through such lengths that you're changing the object, the prestation of the contract, then I think that's, I don't know about you, Robert, but I would say that's moving very far away from a definition of what most people would consider commercially reasonable.
Yeah, I think you're right. I think that there might be commercial reasons to rework production and provide a compliant product. And we saw that with NVIDIA and some others. But whether it would be an obligation, that's a different question. But I agree with you. A lot of this is not just pure legal analysis. There's the balancing of the commercial interests. And you're right. These suppliers, they want to sell to everybody. They don't like it when they're told they can't sell to certain purchasers.
Yeah. No, I think that's exactly that's exactly right. We always have to remember the commercial reality, as you said. And on that note, unfortunately, I would just repeat that we're in a situation where that does not favor purchasers here in China. If there was a glut of semiconductors on the market, if the industry was really hurting, they were not operating at capacity, they would bend over backwards to get these licenses to rework products. But the reality is the incentive is not there. Okay, so going back to the example about Huawei that I gave a moment ago, again, this is all public. I encourage you to look through the Wall Street Journal, Financial Times. You'll see the management at TSMC, when they were asked about not selling to Huawei, they said this would not impact their revenue projections. This was a essentially revenue neutral change to their business. The reason being was there was a chip shortage. They were at 100% capacity. Even though Huawei was their second biggest customer, all of that capacity could be and was, in fact, this happened while I was there. It was all reallocated to NVIDIA needed the chips for GPUs, Apple needed them for iPhones, Qualcomm needed them for probably systems on a chip that were going into laptops that we all needed for Zoom calls back in those days. So it is a very singular commercial environment, and should never lose sight of that. It's very impactful. Okay, so moving on to two other points in these force majeure clauses that you want to cover off. These are a bit simpler, thankfully. Notification. Did the party trying to invoke this comply with their notice requirement? Did they notify you in time? Did they, assuming the language requires this, provide reasonable detail about what the problem is, why they're actually prevented from delivering? Did they provide any details, any substance at all on how they're going to mitigate this? If you are a supplier, it's one of your important rights. You want to enforce it as much as you can. The fourth and final, and this is more complicated, and this one could be a bit uglier, is what are the consequences of the force majeure, especially an enduring one? Is these export controls tend not to go away. What are the consequences for the contract? Usually it's going to end with the party that's not invoking the force majeure event having a right to terminate. This is, I mean, that's not really terribly helpful, I would say, because you want the items that you purchased and maybe partially paid for to be delivered, especially in this context. Even if you get a down payment or you get an advance payment refunded, it's still incredibly damaging because you're going to have to find another supplier. That's impossible in many cases, either because there's only one supplier or the other supplier is also impacted by the export controls. It's not terribly helpful, but yeah, that's usually what you're left with. And again, I mentioned advance payments, down payments a moment ago. It is worth highlighting that these force majeure clauses, they are providing for termination. They're not providing for rescission. So there's no suggestion that the parties are going to be put back in totally made whole, put back in the position that they were pre-contract. That may be the case. There may be something else in the contract that says, oh, you get your advance payment refunded, but that may not be the case. And it may be the case, in fact, that your supplier has made something bespoke, like systems on a chips that are meant for a specific phone that cannot be sold to somebody else. And they are not whatever advance payments, down payments that you've turned over, they're not gonna part with that happily. So that is something to keep in mind. All right. Well, I think we've talked enough about force majeure. Let's talk briefly about some of the other, key clauses that key clauses in our checklist that you're going to want to run through when you're in this sort of crisis management mode. Another thing you're definitely going to want to look at would be limitation of liability. Um, I would say almost for certain this is for certainly going to be in the clause, almost certainly going to have it. I mean, it is standard to see in this industry something where liability, and there might be carve outs for IP breaches or breach of confidence, trade secrets, that sort of thing. But put that aside. Usually, there will be a limitation of liability that limits liability to the value of the contract or some multiple thereof, not a high multiple. And that's a problem because the amount of lost profits, the amount of disruption to a business, the not having something like this delivered on time can cause a business. It's going to be well above the value of the contract. I mean, it's not even close. And I don't think there's any good news here. When you check these things, you're unlikely to find a pleasant surprise. But I think it's better to get the bad news up front so you can prioritize and you can plan for that. Yeah, I think bad news is better than a very bad surprise that comes late in the game. Yeah. So again, most of these clauses they'll make a lot of your damages effectively unrecoverable. I mean, you may want to look into what the governing law is to see what extent they're enforceable. But it's a difficult issue, I would say, for suppliers. Okay, the second one, this is a pretty simple one. You just tick this box, look at the dispute resolution clause. Where are you going with this? Is it arbitration? Is it local courts? Are there notice requirements? If so, you're gonna want to comply with those right away. Otherwise, you could jeopardize your interest in recovering anything. Yeah, finally, governing law, that sort of thing. This is also relevant, not as important as force majeure. I think you're going to want to pay particular attention to this because, in all likelihood, you will be trying to enforce a foreign judgment. I mean, most of these contracts that are impacted by export controls, they are by their very nature going to be cross-border. The parties are in different jurisdictions, so almost for sure this is going to come into play in one way or another. Okay. So look, I've spent the past couple of slides talking in what I hope is not too painful detail about how hard and difficult, complicated all of this can be. But I do want to finish on a slightly more positive note. The industry definitely has moved forward. The legal departments of the semiconductor world and their lawyers in private practice, I mean, they're not blind to all this. They are aware of these changes, and they have kept pace with this. So what you're seeing now in newer agreements, or what you'll have to contend with if you're negotiating a newer agreement, is going to be export control specific language. So to clarify, I don't mean they're going to write that into the force majeure clause. This is going to be something separate and independent, and it's a lot cleaner that way. And just as a principle of contract law, obviously, I wrote it there. The Latin is lex specialis. The specific takes precedence over the general. Force majeure language by its nature is very general. This is something more specific. So for the purposes of this slide, put the force majeure clause aside. What you can focus on is the dedicated language, and that is probably not, for reasons that I've mentioned, going to be very favorable to the purchaser. It's usually going to say something along the lines of export controls are implemented, they impact or impede or hinder delivery or performance of the agreement. When that happens, there'll probably be a notice requirement and performance will be suspended for, let's say, 60 days. Both parties have an obligation to meet and have good faith discussions. But that's all they are. I mean, you're hoping you wind up with a scenario like the one Robert mentioned with NVIDIA, where they come to the table and they can do something. If it doesn't happen, you're effectively looking at a unilateral right to terminate by the supplier. And yeah, if you are negotiating one of these clauses for a purchaser, try, if at all possible, to negotiate some language into it saying that you're saying that any advance payments will be returned plus interest. Use all the leverage you can to get that. The supplier is going to say no claims. And on that somewhat more positive note, I think I'll end it there.
All right. Thanks so much, Greg. That was an outstanding presentation. In my past life, when I worked in-house at Nortel Networks, we dealt with a lot of similar issues as what you've described. And of course, you were describing just some limited categories of contract clauses that relate to today's topics. And there are many more that you would have been dealing with on a regular basis. And even though it's a different industry, there are a lot of these elements that are similar, but the context can be different. And what I thought was very important was how you, throughout the entire presentation, emphasized the importance of understanding the commercial context. And that as lawyers, we have a particular role. And sometimes, in order to perform our role as lawyers, it's not related to our knowledge of the law. It's related to our knowledge of how contracts are drafted, how the law interprets those contracts, but also how the commercial realities impact how the parties will, in fact, negotiate. And I agree with you that as lawyers, we're putting in place a framework to put our commercial colleagues or clients in a position where they can negotiate the best solution. But when I was at Nortel, we were the supplier, and we had a rule that we never sued our customers. And that was because of a commercial reality that there were more suppliers than there were operators who were our purchasers. So
the opposite reality.
Yeah, we couldn't afford to burn our bridges with a customer because we depended on them for future business. And the only exception would be if this was, and there was a period of time during the dot-com bubble when there were a lot of new category telecom operators, and they were buying all this equipment, but then they were not continuing customers because they had a bad business model, and therefore we could burn our bridges with them. So these are the types of commercial realities that we have to keep in mind. And I think that your presentation this evening illustrated a lot of those important commercial realities.
Yeah, thanks. And I would say actually this is something that's going to be more challenging here at China side, because what you're seeing is I mean, there's a lot of progress is being made by the China players in this industry, but a lot of the companies are new entrants to the market.
Yes.
Especially now, there are a lot of government subsidies. There is a big push, both by government and industry, to advance in tool manufacturing. So the reality is a lot of the lawyers in private practice or in-house, they are relatively new to the industry.
That's right.
And these are things that you really only know if you've done it and you've seen it.
Well, those who have followed some of my presentations over the years or participated in some of my training may know the story about when I moved from private practice into the in-house position at Nortel. And I had already been practicing for 10 years at that time. And I felt like I was a reasonably mature lawyer. And a lot of people think that supply contracts, procurement contracts are relatively simple. But actually, I felt that even as a lawyer with 10 years experience, it took me 6 months before I felt like I really understood how our supply contracts worked and where the issues were and how I had to understand the related commercial realities. I'm assuming that working in the semiconductor industry, you felt that there was a similar type of ramp up time before you felt like you had your arms around all of the issues.
Yeah, absolutely. I did think that there was a learning curve there. And I would say, the problem is these things are deceptively simple because
Yes.
you see these contracts and you do see all of the commonalities. What you don't see is behind the contract, there's a commercial reality that's foreign to you. And the challenges are really what are unseen, what's much more difficult to detect and to learn how to handle. And I think that's something that it just takes time.
I also noted that you found these technical drafting and analysis questions to be very interesting. So that means that you are well qualified to be a lawyer because only a lawyer can find joy in this type of drafting and analysis. But actually, that's why I enjoy being a lawyer because I enjoy the same issues. But what I think is very valuable is that you showed two different examples of force majeure clauses. Now, most lawyers do not even look at the force majeure clause. We just think that it's standard. We think that it doesn't apply. But now we've had some examples from the pandemic where everybody was looking at their force majeure clauses. And now you're providing another illustration where government action, geopolitical conditions resulting in export controls, sanctions, et cetera, can impact how we have to look at the force majeure clause. And I think that applies in a lot of cases, things that sometimes we think are simple and straightforward in a different context can be quite critical. And we have to be able to pay attention to that language. So I think that your explanation of the core elements of a force majeure clause was actually really outstanding and very helpful to put it in those four categories.
Yeah, that's great. No, I do think it remains a very salient issue, especially for a lot of the older legacy contracts that are out there. So what you see is the foundry service agreements in particular. They are very, very long term. So you could have one that's signed, 10 years ago, and the purchaser just keeps making purchase orders under it. It's more like a master service agreement.
Right.
And the purchase order, as long as the purchase orders are still being processed, you think it's fit for purpose because nothing's changed. Well, the reality is a bit more complicated. So, and there's still plenty of these floating around, I think.
Now, we had a question from one of our lawyers who's attending the program this evening, and he was asking about the two different categories under export controls: advanced semiconductor manufacturing equipment that is subject to export controls, and then others that are not as advanced, so therefore not subject to the controls. But does somehow the impact or the controls over the advanced equipment, does that somehow influence the procurement and the contract language and negotiation for the other non-advanced or non-controlled semiconductor manufacturing equipment?
Yeah, I think it should actually because I think I hate to say this because you'll think I'm too pessimistic, but it's a lawyer's job to be pessimistic. You'll hate it, but you'll agree with that, right, Robert?
Yes, I do.
Okay. Like I said at the outset, it is a moving target, so I would treat those things almost the same, really. I would try to have the same language. If it's older, more mature technology, I wouldn't fight for it as hard.
Right.
But I think it will be unwise to underestimate how far these export controls can be taken. I mean, just to give you an example, there are now, and this is less relevant China side, but just by way of example to show how far this can go. There are EU regulations mandating that no re-export to Russia clauses be drafted into all commercial agreements.
Mm.
And look, I mean, Russia's very much a separate case. It's, we don't. I don't think we're going to get to that stage in this part of the world anytime soon. But this is just an example of how far these things can go. And I think it would be wise for even for less mature technology nodes, less mature technologies, to have some of the same protections.
Now, we also have discussed that some of the original sources of supply have now been cut off because of the export controls. So some equipment from ASML, for example, some chips from TSMC or NVIDIA or from Samsung may no longer be purchased by some Chinese players in this sector. So some of the supply is going to be coming through domestic transactions, yes. Domestic suppliers who are advancing in their capabilities. But as you mentioned, there are a lot of new players and a lot of in-house lawyers and law firm lawyers who are new to drafting these contracts. So what would be your advice? How can they come up to speed? Because the issues on export controls may not apply 100%, but a lot of the other issues that you dealt with when you were at TSMC or when you were in working as a law firm lawyer in the semiconductor industry, those would still apply. If you're coming fresh, as I said, I was a 10-year lawyer, but I felt like I needed 6 months before I came up to speed. How does someone who's new to this industry, how do they come up to speed?
Yeah, good question. So I think you're right. We could for a purely domestic procurement or foundry service agreement, we can safely put the export controls aside, I think. But a lot of the challenges do remain. I do think that the procurement issues about where demand is massively outstripping supply, that's still very much there. So whether it's a purely domestic transaction or a cross-border one, everything I said about delivery dates, that still applies. And a lot of the other issues that we didn't have time to talk about tonight, they're going to be there too, and you might not see them if it's your first attempt at drafting and negotiating one of these agreements. And I would think, look, I mean, normally these agreements, these procurement agreements, they're done in-house. I saw a lot more of these when I was at TSMC than when I was in private practice. But I would suggest that for new players, new in-house legal who have not done this before, I would think for the first go around, they don't want to improvise. I would think you should reach out to external counsel, and it's very likely that that's going to be a one-off or almost a one-off thing. I would think going forward, this is going to be, these procurement contracts are typically done in-house. This is one of the classic in-house lawyer specialities. But I think at the outset, you do need a second set of eyes, and it has to be a set of eyes that's seen this before, because this is a very unique beast. Like you said earlier, the commercial environment always matters, and as I've really tried to stress here ad nauseum, this is a very singular commercial environment, and it's one that has a very singular impact.
Well, your response to my question was in line with my expectation, and I would just add a slightly different gloss. So first of all, everything that you said about how capital intensive all of this equipment is, the timing, how it has to be coordinated, questions of penalties or right to delay, all of those things, I agree, should apply in this sector, even if it's purely domestic. But I will have a slightly different view on the export controls. Yes, directly it would not apply, but there may be something up the chain that may be impacted by an export control that then cascades down and impacts the supplier's ability to deliver. So I think there is still something there. We have to look at
Fair.
that. And there's another part, and this is going to be an interesting thing. Actually, I'm planning to do another either webinar or a training session or something as part of a training session on how to work conflict of law when you have sanctions or export controls that have extraterritorial jurisdiction. And then, as we do in China, if you have anti-sanctions legislation and blocking rules, then how do you negotiate these export control clauses where the one side says we must obey, therefore you must obey, and you say, well, under our law, we cannot obey. So those are issues that may come up as well. I think these are all very interesting and complex issues.
Oh, yeah, absolutely. Absolutely.
The last point, to go off of what you were just saying about how does someone ramp up, I was going to comment again about the difference between an in-house lawyer, someone who's really seen it hands-on, day-to-day. That's very different. After I had ramped up, in my first 6 months at Nortel, I believe I was then legitimately an expert in that type of contract. And then I continued to do that for several years and refined my ability, saw it in different contexts, different commercial realities, et cetera. So I became the expert. And what we found is that we were not able to instruct outside counsel to step in and help us with those because it took us longer to try to train up outside counsel because they really didn't have any idea how to do it than it was for us to just do it ourselves. But what you're saying is absolutely critical. And that is, if you can find a true expert, someone who's had that in-house experience, has seen all of that, has reference material. Obviously, everything at TSMC, there's nothing you could take with you. That may be
No, sir.
that might be another interesting webinar at some point to talk
It will
about
be.
security measures that these high-tech companies put in place, and Chinese companies do that as well. But in other words, there's a difference between your typical law firm lawyer who's not had the deep experience of being in-house and dealing with this at a world-leading player, as opposed to someone who has had that experience. So I agree with you. I think that people who are new to the industry, they need to find an expert to help them with that process. And I think tonight we introduced all of their lawyers in attendance to a true expert. So we thank you for sharing your expertise. Thanks very much.
Yeah, no, it's my pleasure, Robert. And all I would say is, I agree completely. And I think the point that illustrates this the best is when we were first started off and we were talking about late delivery.
Right.
I don't think it made sense at the outset when I said, oh, when you're a purchaser, you're going to want to write the delay. I mean, there are, I'm sure, tons of outstanding commercial lawyers in private practice who would not think to address that in a contract.
I agree.
Even think that, but it's huge. One of the most important things, and I think that illustrates the point well.
I agree, and thanks so much. We will be displaying a QR code so that people who wish to receive copies of your excellent PowerPoint will be able to scan the QR code, and we will send the PowerPoint slides to anyone who requests them. Thanks again, Greg, and we look forward to having you again at some point. Good evening.
Yes, absolutely. And I think my email address is on the slides, so anyone who has any questions, they're more than welcome.
All right.
Okay, thanks so much, Robert. Take care. Bye.
Good night.